Hi everyone, welcome to our channel. CBIC White Circular 178/10 2022, dated 3rd August 2022, has issued clarification on few of the most litigated matters like liquidated damages, compensation, late fees, etc. So, let us go into the video and see what the circular has clarified. So, Circular has issued clarification regarding various activities that falls under Para 5E of Schedule 2 of CGST Act 2017. Earlier, Para 5E of Schedule 2 was linked to the charging section 7 of CGST Act 2017. Later, with a retrospective amendment, it was delinked from the charging section of what constitutes a supply. So now Schedule 2 is actually used to determine whether a particular activity is supply of good or supply of service. It does not determine whether it is actually a supply to fall under the purview of GST. So, Para 5E of Schedule 2 of CGST Act 2017 states that agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act has been specifically declared to be a supply of service. So, when it involves agreeing to the obligation to refrain from an act or to tolerate an act or an obligation to do an act, then it will be considered as supply of service as per para 5E of schedule 2. So there were lot of advanced rulings and litigations on various factors, on various activities, whether it will be regarded as tolerating an act or refraining from an act, and whether that will be considered as a supply of service and leviable to GST. And in many advanced rulings, the ruling was given in favor of the SSC, and in many it was against the SSC. So because of all this, CBIC has come with a proper clarification on this. Now, let's see in detail the various elements of Para 5E. The first element is agreeing to the obligation to refrain from an act. Example for the activity that would be covered by this part of expression would include non-compete agreements. So non-compete agreements are where one party agrees not to compete with another party in a particular area, in a particular product or a service. So against a consideration. So that particular activity will be regarded as an agreeing to the obligation to refrain from an act. Similarly, activities like a builder refraining from constructing more than a specified number of floors, even though he is allowed and permitted by the municipal authorities to construct a specified number of floors, but he is refraining from constructing the specified number of floors against the compensation received from another builder who is constructing a flat or an apartment nearby. And because if this person constructs more number of floors, then the other person's sunlight and airflow will get affected. So he is giving a consideration to the first party that you don't construct beyond like 5 floors or 10 floors. I will pay you so much of amount. So that type of consideration will be regarded as an agreeing, that type of contract will be regarded as agreeing to the obligation to refrain from a particular act. Now, the second element is agreeing to the obligation to tolerate an act or a situation. This would include activities like a shopkeeper allowing a hawker to operate from a common payment in front of his shop against a monthly payment. So he is allowing the common payment, the common pathway to be used by another person, and he is getting something in return for tolerating the act of allowing another person to use the common payment. So that will be regarded as tolerating a particular act, and what you get in return, the consideration that you get in return is actually taxable under GST because it is covered in para 5E of schedule 2. Agreeing to the obligation to do an act. So the example that is stated in the circular is as an industrial unit, it agrees to install a zero emission equipment. There is no legal obligation for the industrial unit to make such to install such zero emission equipment, and the emissions are also well within the permissible limit. But because a nearby residential association is requesting and they are paying a consideration to install a particular equipment, they are obliging to that and installing it against the consideration paid by the association. So that is agreeing to an obligation to do an act, and the consideration received will be taxable in GST because it falls under, it satisfies the conditions of para 5E of Schedule 2. And then we will go to the charging section, section 7, to see if it is a supply or not. And if it is a supply, then it will be leviable to tax. Now, the litigations that arose was pertaining to liquidated damages paid for a breach of contract, whether that will be considered as whether the damages will be considered as a consideration for tolerating an act. Similarly, the amount recovered from an employee leaving from employment before the agreed period, whether it will be considered as a compensation, as a consideration that is received for tolerating the act of the employee getting relieved before the agreed period, before his notice period. So, such similar activities, many such similar activities were litigated, and hence CBIC has come with this clarification. So, in the clarification, they have clarified each and every element, like each and every activity which has been litigated earlier. So, and the CBIC circular actually starts with defining what a service is. The service, as per service tax law, is any activity carried out by a person to another person for a consideration. And in the service tax education guide, the concept activity for a consideration has been defined as an element of contractual relationship. So there has to be an element of contractual relationship for a particular activity to be considered as an activity for a consideration, and only when there is an activity for a consideration that flows between two people, it will be considered as a service. So in contract act, a contract is defined as a promise or set of promises forming consideration to each other along with enforceability of law. So that is agreement with, and so enforceability of law is what is a contract. So if for a service of agreeing to an obligation to refrain from doing an act, or to tolerate a particular act, or to do a particular act, there has to be a contractual agreement. Only if there is a contractual agreement, it can be regarded as a service to do a particular act or not. So, this particular element is the basis of defining whether an activity will go into para 5E and later on in chargeable under section 7. So, an agreement to do an act or abstain from doing an act, or to tolerate an act or situation, it cannot be imagined or presumed to exist just because there is a flow of money from one person to another, unless there is an express or implied promise by the recipient of money to agree to do or refrain from doing something in return for the money paid. It cannot be assumed that the payment was for doing an act or refrain from doing an act. So there has to be an agreement between the particular person, between the two parties, for them to abstain from doing an act or to agreeing to do an act in return for some amount. So the first clarification that is issued is in relation to liquidated damages. Liquidated damages are payments made for not tolerating an act. It is not a consideration received, but it is a remedy. It is a compensation for the damages incurred in case of breach of a particular contract. So in case, for example, an agreement to sell, and there is a breach of an a contract of agreement to sell, and the person, the two parties who have contracted, the person who has breached the contract is paying a compensation to the other person. Compensation is to cover the loss, the damage incurred by the other person in case of this particular breach. So it is not a consideration, but it is a compensation. And the compensation is not by way of consideration for another independent activity, it is just an event in course of the performance of the contract. For example, damages, the compensation paid in case of damage to a property, negligence, unauthorized use of trade name, copyright. So these are all the damages which is being compensated, is not a consideration. There is no contractual agreement in this particular matter. Nobody enters into a contract to breach a particular contract, and hence the compensation is not a consideration. There is no contractual relationship, so it is outside the scope of para 5e, and hence it is not taxable. Compensation for cancellation of coal blocks. Compensation paid by government for cancellation of coal blocks pursuant to the order of Supreme Court is not taxable, because it is also a compensation, and there is no contract between the government and the allotee of coal blocks, that the particular contract will be cancelled and you will be paid compensation. They are not entering into a contract for breach of the contract, but they are entering into a contract for performance of the contract, and hence it is not taxable. Check dishonor, the fine and penalty charged on dishonor of check. So there is no implied or express willingness on the part of the supplier that he would tolerate a deposit of an invalid fake instrument, payment instrument, against a consideration. So the fine and penalty that has been imposed for the dishonor of check is a penalty imposed not for tolerating an act or situation, but it is a penalty imposed for discouraging such an act. It is it is to discourage the act. It is not a consideration for tolerating an act, and hence it is not taxable. And there is no contractual agreement in this case also between the two parties that he is willing to accept a particular a check against a fine or penalty, a dishonored check for against a fine or penalty, and so it does not fall under para 5e. Penalty imposed for violation of laws. So there cannot be any agreement for violation of law, because violation or any agreement for violation of law, it is not a lawful consideration, it is not a lawful object, and hence there cannot be any agreement for violation of law, and laws are not framed for violation. Okay, that laws are framed for abidance, and hence a penalty that is imposed, it is not for tolerating that particular violation, that the government is charging a penalty. If a traffic rule is being broken, and you are issued a challan, it is not for tolerating that violation that a challan is being issued. It is imposed as a penalty that you have violated a particular law, and and hence it cannot be considered as a consideration, and there you are not entering into a contractual agreement. There is no agreement entered into. There is nothing in return for the other person. Government is issuing a challan, but the person who has broken a traffic signal, he is not getting anything in return, any benefit out of it, out of this particular payment. So there is no contract, and hence it is outside the scope of 5 para 5e, and it is not taxable. Forfeiture of salary or payment of bond amount in the event of the employee leaving the employment before the minimum agreed period. The amount recovered by the employer is not a consideration for tolerating the act of premature quitting, but it is a penalty that is charged to deter such a situation, to discourage such a situation. And what does the employee get in return? The employee doesn't get anything in return from the employer against this particular payment. There is no benefit involved. There is nothing in return for the employee out of this particular payment. So, and again, with this particular thing, there is nothing in return. So, for a particular agreement, for a particular transaction to be an agreement and then a contract, it is promise or set of promises forming consideration to each other, so each of the person should get some benefit, and because it is not there, it is not a contract. And as there is no contractual relationship, again it is not a service as per the service tax law, and it does not fall under para 5e, so it is not taxable. Late fee or um, late charges that we find in almost all of the business contracts. It is like in our electricity bill, telephone bill. So it is a clause that is provided in almost all the contracts, and it is a facility that is provided by the supplier for accepting late payments against an interest or a fee. So this forms part and parcel of the main supply, and hence it is charged at the same rate as the principal supply is assessed at. So it is a service of tolerating a particular act. So if a person is making a late payment, against the late payment a fee is being charged. So against the particular act of late payment that is being tolerated by the supplier, a fee is being charged. So there is a contractual, it is mentioned, it's part and parcel of the contractual agreement, and there is something in return for each other. So it is um, assessed under para 5e and subsequently assessed to tax also. Fixed capacity charges for power utilization. So in case of all our electricity being supply to individual consumers, there are two type of charges. One is fixed and one is variable. The fixed charges remains fixed irrespective of the quantity that is utilized. So such fixed charges are also part and parcel of the sale of electricity. It is not any charge that is imposed by the supplier for usage or non-usage of a particular product of the product of electricity. So it is not chargeable to tax, and it is exempt from GST. Cancellation charges. Cancellation fee can be considered as charges for the cost involved in making arrangements for the intended supply and the cost involved in cancellation of the supply, such as cancellation of railway tickets, etc. So it is like a facilitation supply that has been offered against payment of cancellation fee, and hence it is covered under para 5e, the act of tolerating a particular act. So it will be assessed to tax at the same rate as that of the principal supply. Like cancellation charges of railway tickets for a particular class, like for AC it will be 5%, and for non-AC it will be nil. So the same rate that is applicable to the principal supply. Thank you. Thank you for watching the video. Do like and subscribe if you like the video, and have a great day.